There was a number sitting inside an executive order signed on September 19, 2025. $1 million, not a visa fee, not a processing charge. A $1 million payment, described in official government language as a contribution, that would buy a foreign national permanent residency in the United States. No extraordinary ability required, no advanced degree required, no proof that your work would benefit this nation. Just $1 million and a place in line that had previously been reserved for the world's most talented scientists, engineers, researchers, and professionals. When immigration attorneys across the country read Executive Order 14351, the room went quiet. Not because they didn't understand it, because they understood it completely. And what they understood was that the line, the legal, congressional, statutory line that separates a visa system built on merit from one built on money, had just been crossed. What the Trump administration did with the Gold Card program moved something that Congress built, something Congress designed, something Congress specifically protected, and handed it to the highest bidder. And when that line broke, experts, applicants, and legal scholars did not hesitate. They responded with urgency, precision, and a federal lawsuit that is now sitting inside a courtroom in Washington, D.C. Most people watching this think the Gold Card is someone else's problem, a program for the ultra-wealthy, a policy that doesn't touch them. They make the mistake of looking away. But today, you are going to understand exactly why this case touches every single person waiting in an EB1 or EB2 line, and why the court's next move will reshape employment-based immigration for years to come. For months before the lawsuit was filed, there had been signals, not from immigration advocacy groups, not from congressional hearings, just signals that this administration was preparing something that would fundamentally restructure how employment-based green cards are awarded. The administration had been bold, yes, but also deliberate in that approach. Every action followed a pattern, an executive order, a policy directive, a new form introduced quietly through USCIS. Almost a sequence. Executive Order 14351 was signed in September 2025. Then, on November 19th, 2025, USCIS introduced Form Y140G, a brand new form designed specifically for Gold Card applications. Then, on December 10, 2025, the program was publicly launched with official statements from administration officials defending its legality. The infrastructure was being built deliberately, piece by piece, before any legal challenge could slow it down. But what triggered deep alarm inside the immigration law community during this period was that something critical was missing from the entire rollout. Immigration attorneys who monitor policy implementation recognize the indicators: the absence of a notice and comment rulemaking period, the absence of any congressional vote or statutory amendment authorizing the new category, the absence of any formal response from DHS or USCIS about what would happen to existing EB1 and EB2 applicants already waiting in line, the sudden creation of a separate form, a separate fee structure, and a separate adjudication track, all without a single word from Congress. And when an administration builds a major immigration program without congressional authorization, something significant is coming. On February 3, 2026, the United States District Court for the District of Columbia received what immigration legal experts immediately recognized as one of the most consequential immigration lawsuits filed in years. The American Association of University Professors, along with individual plaintiffs, filed case number 1-26 CV-03 formerly known as American Association of University Professors versus the Department of Homeland Security. The complaint described what the plaintiffs called a pay-to-play scheme, a program that, in their words, converts employment-based visas that Congress reserved for the world's best and brightest into revenue-generating commodities sold to those who can pay $1 million or more. These are legal arguments an organization only makes when signaling something specific: that the executive branch has exceeded its statutory authority, that Congress, not the president, holds the exclusive power to regulate immigration and raise revenue, or that the administrative process used to create this program was fatally flawed from the beginning. Observers weren't certain which argument would carry the most weight in court, or whether all three would move together. But one thing was immediately clear: the administration was changing the architecture of employment-based immigration without asking permission, and when that happens without congressional authorization, a federal court pays attention. The legal challenge issued in this case was not a symbolic protest. It was not a political statement. It was a surgical, three-part demand filed in federal court. Legal experts who reviewed the complaint described the case as technically strong, constitutionally grounded, and most importantly, potentially dispositive, meaning that if the plaintiffs succeed on even one of their core arguments, the entire Gold Card program could be halted by injunction before a single visa is issued under it. But legal challenges only work if the court agrees to hear them on the merits. The administration did not hesitate in defending the program publicly. Their response was to stand by the executive order, assert presidential authority over immigration policy, and continue the program's operational rollout while litigation proceeded. The legal confrontation was now fully underway. The lawsuit confirmed 3 specific legal violations that the plaintiffs are asking the court to recognize. First, the Gold Card program unlawfully modifies EB-1A and EB-2 NIW visa categories without congressional authorization. The EB-1A category was created by Congress for aliens of extraordinary ability, people at the very top of their fields in science, education, business, arts, or athletics. The EB-2 national interest waiver was created for professionals with advanced degrees or exceptional ability whose work is in the national interest of the United States. Both categories have explicit eligibility criteria written into the Immigration and Nationality Act. Neither category allows payment to substitute for merit. The Gold Card program, created by Executive Order 14351, instructs federal agencies to use visa numbers from these exact categories for Gold Card applicants. That means a person who paid $1 million is now drawing from the same pool of visas as a physicist from India who has been waiting in the EB-2 backlog for over a decade. Second, the Gold Card program was implemented without the notice and comment rulemaking that the Administrative Procedure Act requires for major policy changes. The APA is one of the foundational laws governing how federal agencies create rules that affect the public. When an agency wants to make a significant change to how a federal program operates, it is generally required to publish the proposed rule, accept public comments, review those comments, and then issue a final rule. None of that happened here. The Gold Card program was announced by executive order, operationalized through a new USCIS form, and launched publicly, all without a single day of public comment. That procedural shortcut is precisely the kind of agency action that courts have struck down before, and the plaintiffs are asking this court to do exactly that. Third, the program violates the numerical caps and allocation rules that Congress built into the immigration system. Congress places a statutory cap on the number of EB-1 and EB-2 visas that can be issued each year. Congress also requires that visas within each category be allocated in the order in which applications are filed. The Gold Card program creates a separate, prioritized track that pulls from those capped numbers, meaning Gold Card applicants move ahead of merit-based applicants who filed earlier, simply because they paid more money. The lawsuit argues directly that this will increase EB-1 and EB-2 wait times and result in qualified merit-based applicants not being awarded visas they are legally entitled to. This is not a theoretical harm. This is a measurable, documented consequence of inserting a new class of prioritized applicants into an already oversubscribed visa category. Now let's be precise about who this affects, because this is where most people watching this video need to stop and pay very close attention. If you are currently waiting in the EB-1A or EB-2 NIW backlog, this lawsuit is about your case. If you have an approved I-140 in either of those categories and you are waiting for a visa number to become available, this lawsuit is about your timeline. If you are a researcher, scientist, engineer, professor, or skilled professional who built your immigration pathway around the merit-based criteria that Congress created, this lawsuit is about the legal foundation of your status. The Gold Card program does not create new visas. That is one of the most critical facts to understand. There is no expansion of the annual numerical cap. There is no new allocation of visa numbers. One of the most important clarifications to emerge from the lawsuit is that the Gold Card is not a new immigrant visa category. It does not come with its own numerical allocation, eligibility statute, or place in the preference system. AILA. What it does is insert a new class of applicants, those who can pay $1 million, into the existing pool of visas that Congress designated for the most extraordinarily qualified people in the world. Every Gold Card visa issued is one fewer visa available to the merit-based applicant waiting behind it. That is the direct, concrete harm the lawsuit is arguing. Now let's talk about the legal landscape this case is entering, because context matters enormously. How a court may evaluate these issues becomes clearer when viewed through the Supreme Court's treatment of executive power under the International Emergency Economic Powers Act. In that analysis, the court focused on statutory text and structure, and on whether Congress had clearly authorized a move with major economic consequences. The court rejected the idea that general statutory language could be stretched to support a major policy shift absent clear congressional authorization. AILA. That framing is directly relevant to the Gold Card case. The Immigration and Nationality Act sets out detailed eligibility criteria, numerical limits, and allocation rules for EB1 and EB2 visas. If the Supreme Court has signaled that it will not allow the executive branch to stretch general statutory language to justify major policy shifts, that principle applies here with equal force. Immigration attorney Ron Klasko stated that if the D.C. court finds that the plaintiffs have standing, there is a good chance that the gold card will be found to be unlawful for a number of reasons, including the lack of a statutory amendment passed by Congress, the lack of APA notice and comment regulations, and a fee set without following the statutory requirements, among others. USCIS. That assessment from a respected immigration attorney is not a political opinion. It is a legal analysis of the program's structural vulnerabilities under existing law, and it signals that this case has real teeth. There is one important counterargument that the court will also have to consider. Immigration attorney Brad Banias raised the question of whether plaintiffs can demonstrate standing, noting that the gold card expands the pool of potential applicants for EB1 and EB2, and that plaintiffs would have to explain how gold card applicants from one country affect merit-based petitioners from another. USCIS standing, the legal requirement that plaintiffs show they have suffered a concrete direct harm, is the threshold question in federal litigation. If the court finds that the plaintiffs cannot demonstrate standing, the case could be dismissed before the merits are ever argued. That is a real possibility, but it is not the only possibility. Attorney Stephen Reingold stated that this is likely the first of many lawsuits that will address the gold card and its compliance with various federal laws and regulations. USCIS. If the AAUP case is dismissed on standing grounds, additional lawsuits with different plaintiffs who can demonstrate more direct, individualized harm, could follow. The legal challenge to the Gold Card program is not a single shot. It is the beginning of a sustained legal confrontation. Here's what every EB1 and EB2 applicant needs to do right now, regardless of how the case unfolds. First, do not pause your existing application while waiting to see what happens in court. Continue filing, continue responding to RFEs, continue maintaining your eligibility documentation. The gold card litigation could take months or years to resolve. Do not put your case on hold for a court decision that may or may not come on your timeline. Second, if you are considering applying for a gold card, understand the financial risk clearly. Before paying any non-refundable amount, request written program terms showing what happens if a court pauses the program, the refund rules, and which statutory category you are being processed under and what evidence standard applies. MONDAC, a payment described as a gift, may be non-refundable even if a court later pauses or invalidates the program. MONDAC $1 million is not a small risk to carry in pending litigation. Third, if you are an EB1A or EB2 NIW applicant who believes the Gold Card program is materially harming your place in the visa queue, consult an immigration attorney about whether you have standing to participate in or support existing legal challenges. Fourth, track case number 1.26 CV00300 in the U.S. District Court for the District of Columbia. Court filings, motions, and orders in this case will be publicly available. Any motion for a preliminary injunction, which would temporarily halt the Gold Card program while litigation proceeds, is the filing to watch for. Fifth, watch for congressional reaction. The lawsuit's argument that Congress, not the president, holds the exclusive authority to create visa categories and raise immigration revenue is an argument that invites Congress itself to respond. If members of Congress introduce legislation either codifying or blocking the Gold Card program, that legislative move will affect the litigation's trajectory significantly. As the months continue, more will emerge about how the court evaluates standing, whether a preliminary injunction is sought and granted, and whether the administration chooses to defend the program aggressively or modify it to address the legal vulnerabilities the complaint has exposed. But one thing is already clear. Understanding this case right now does not make you paranoid. It makes you prepared. It means you are not sitting in the dark while a legal battle reshapes the visa category your future depends on. It means you are protecting your application, your family's future, and your legal standing with real information. Information that most people will never take the time to find. Share this video with every EB1 and EB2 applicant you know. Share it with every skilled worker, researcher, professor, or professional who is waiting on an employment-based green card. This case is about their place in line. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.